if you're in that situation, then we should at least speak about that.
That's a common oversight
Yes.
in a lot of the planning meetings that we have. I'm sure Bill can attest to that, where people go through the process of planning for their own assets, but they forget that they own a business, they've owned it for years, and what happens with the business, right? It's usually overlooked.
So I had a question about that, because saying that you're saying corporate assets, I'm thinking that you're saying specifically for corporations or like I guess an LP, right?
Yeah.
But what about sole proprietorships in that situation?
Okay, so sole proprietors don't fall into this category, unfortunately. That's another part of the planning, right? You need to consider whether you should incorporate. Sole proprietorship means you are one and the same as your business. So whatever's in your business will go into your estate. There's no division, it becomes public knowledge, right? Secondary wills, because they're not going through the probate process. Whatever assets you have in there, they're also kept private. Your personal wills will have to go through the court process. You do have to serve the beneficiaries with notice of them and provide them with a copy of that will, right? But if you have a secondary will and you have different assets that are in there, nobody needs to know about it, including the people that are in your first will. They're not entitled to that, okay? So it does give you some privacy, yes.
Who is actually entitled to read the will? Is it just the named beneficiaries, or is it other family members in sort of the circle?
No. So the only people that are entitled to be notified of the will, this is how it works. If you have what we call residual beneficiaries, so you say everything that I have left over, I'm dividing equally between A, B, and C, right? Then A, B, and C get a copy of the will, and they need to know what they're entitled to inherit, okay? If you say, I'm giving to my niece my car, and you name the car and you say, if I own it at the time that I pass away, and you pass away, well then your niece only gets to get that little paragraph in the will that says, hey, you're a beneficiary, you're gonna get the car, right? We'll figure out the value of it and whatever, and we'll give it to you once everything is said and done. Other family members, it's none of your business. So unless the other beneficiaries wanna share it with them, or you share it with them while you're alive for whatever reason, they don't need to know anything, and they actually don't get involved in it.
What happens if
Go ahead, Brian.
there's other family members and, you know, it's a big estate and they feel like they have a claim to that will? 'Cause I know this one
Feel
firsthand.
whatever they wanna feel.
Yeah.
Wow.
Yeah.
That's what's going to decide it, right?
What
Because
recourse do they have?
They don't. If they find a lawyer that's willing to take them on and try to argue with the court, like, so that's a very, so let me just back that up for a second. Why does that family member feel that they're entitled? Have they done something or contributed in some way to this person's, building of their estate? Like, is it like a common law spouse who can claim unjust enrichment if they get nothing from the from the estate, and they're gonna claim that they should, technically speaking, they should have a trust basically set up for them, even though they're not written in the will? Or is it just a random family member? Right? On most occasions, they don't have the right.
Feelings are for fingers and for calling the lawyer.
Yes.
Basically, you're talking about challenging the will. And that's an interesting point you just made there, where if a specific gift is identified in the will,
Yes.
then the beneficiary is entitled to know what that is, but not necessarily entitled to know unless they're named as the residual of the estate as a share of.
Yes.
That's interesting. So how you structure the will and the language you use can be very important.
Yes.
If privacy is important, you just want to make sure that somebody gets a specific amount, and you don't want them to be privy to everything else. That's where the executor is important. That's where working with the lawyer is so important.
Does not the lawyer have a copy of the will so that when that person passes, the lawyer advises or will send notification to the people who are listed as beneficiaries in the will, and only they get
So how it works is,
notification?
the person that helps you prepare the will doesn't necessarily need to be the lawyers that help you administer the estate. We can be, and I'm happy to be, like that's often how it works with me and my clients. They'll come back, or their family members will come back once that person that I prepared the will for has passed away, and we'll continue with the estate administration of it, right? Sometimes they have their own lawyers, and they're gonna get you need the original will and the affidavit of execution is what it's called, which says, I signed my will today in front of these two witnesses, and et cetera, okay? So you need the originals of both of those, and then you can apply to the court to become appointed as the trustee, all right? The lawyer's job, it's actually the trustee's job to notify the beneficiaries. Lawyers often will do it for them or as part of it, right, as part of the exercise, but if the person being appointed as the trustee then needs to say, I've been named as the trustee, I'm applying to the court to become appointed as the trustee. You're a beneficiary, so here you go as your copy. And then in the application, when we're submitting it all to the court, then we're confirming that all the beneficiaries have been, notified. Is that clear? Yeah?
Yes, thank you.
No problem. Yes. Who's first?
Okay, I just, a quick question, kind of related to this one in a sense.
Yeah.
But is it, I've heard, been told that if you don't want somebody to get something, so you mention it and say they're getting $1, and then they can't contest because they're still getting something from it, but they're just getting $1. So it tries to stop that from somebody contesting, oh no, I deserve something
I mean,
more.
that sounds like a horrible idea to me.
Yeah, but-
Because now you put them in a document, they know there's a will, they know, and it's, I don't know, I would feel slighted if somebody gave me $1 in their will, I'd be like, what's happening here? I think there must have been a typo, right? Like,
Yeah.
or I was so close and, you know, they didn't mean to just give, like, no, if you're gonna leave them out, leave them out.
Okay, you don't have to.
You know what I would say though? If it is somebody that's in like close relationship, and this is, I think one of the big things of estate planning is having the conversations. Don't leave people to be surprised at the end. If you know it's gonna cause a problem between your family, between siblings, between whoever it is, you talk to them. Don't leave it to them to try to clean up your mess at the end, right? When people are aware and they know why, like if you're naming one child as a trustee, for instance, or as a power of attorney, and you're leaving the other one out, explain to the other one, this is not because I love you less, it's just because, you know, they're living here, you're living in the US, whatever it is, right? Have those conversations so they understand that this is not an insult, you know, if that's the case, right? Or if you are making an unequal distribution, like I actually just almost wrapped up, I wrapped up in estate administration for a client, and I helped her do her will, and she has 2 children. And very close to one child who actually like helped her, took a lot of care of her and stuff like that. She named this daughter as the beneficiary, like she changed her, when we were doing the estate planning and we talked about it and putting beneficiaries on some of her registered investments, she changed the beneficiary to be her daughter only, okay? So son was left out of it. Now, the son was a residual beneficiary of the rest of it, right? But he knew mom had some of this stuff. So he was trying to challenge some of this. And we crossed our T's and dotted our I's, so we were okay at the end of it. And I just had to say, no, I had conversations with her. I assure you that she wanted to do this because Kathy was her name and the daughter was, you know, her primary caregiver, and she wanted to show her some appreciation and whatever, and this is the instruction. And then he went to the financial advisor, asked for their contact information. I said, no problem. And I'm speaking to the trustee, obviously, because she's now my client. But they got the contact information of the financial advisor, and they said, no, here's her original signature on the documents. She met with me, this is what she wanted, you know. I could confirm there was no capacity issues with the mom when she signed these documents, right? That's a big way of challenging wills, that it was done under duress or incapable, things like that, right? So when you have somebody helping you with the estate plan, you have evidence, which is helpful. Yeah.
So, it's along the same line.
Mhm.
What if somebody is mentioned in the will,
Yes.
but it's mentioned that they are to receive nothing?
You don't do that.
It was,
I mean, I couldn't do that. And
Yeah.
how long ago was this done?
it was done about 10 years ago. But
Yeah.
there's another situation that could be coming up with another family member along the same line, so I just want to prepare myself for it.
I mean, why? My head is thinking, why would you do that? If you don't want to include them.
Yeah.
It doesn't look like an omission.
Hmm?
It doesn't look like an omission.
Yes, so sometimes, yes, that's right. So sometimes we will do that if it says, you know, I've recently separated from my spouse or whatever it is, and it's, you know, like there's some, but it's not, it doesn't mean anything. Do you know what I'm saying? Like it's not really binding. If you haven't put them, if you haven't left anything to them, you haven't left anything to them. Right? If it's because of children that you think might be disputing what you're doing, you just keep clear evidence of it, you know?
Because there's one that's.
Yeah, give us your example. Give
The
us an
example is a niece was given money a number of years ago.
Niece, you said?
Yeah.
Okay.
From her mother And now she's saying that she wants something when her mother goes, but her mother's had it written in that she's not to receive anything because she got X amount of
Oh, yes,
dollars at
okay.
one
She
time.
gifted, she
Yeah,
gifted
that's
it early.
different.
Yeah.
Yeah.
So
So that's okay,
Yeah.
like if you need to do that or you want to do that, that doesn't hurt, because then you're saying this is the reason that I'm leaving this person out.
Yeah.
I've already given them this, and now everything is going to be divided. I mean, it's still not typically how we'll do it, but look, you have to cater these things to everybody's circumstances, right? And that's where the nuances come in, so.
We've seen that in a number of conversations when we're working on the planning side of things, where individuals are choosing to gift some money early to adult children to facilitate maybe home purchase, life events, whatever. But they also have the conversation, we're making provisions in our estate plan that if we just gifted you, $200,000 for a down payment on the house, that's coming out of the back end.
Yes.
But see, communication is so important in that, as opposed to we're just going to leave a one-liner in there and just say, no. I specifically say no, to specifically you, right? Right? Talk about the last word. I mean, someone leave with that meeting with a bad taste.
And at the end of the day, what does the law say? This niece can be upset. She may be upset, she might think she's entitled, and it doesn't actually make her entitled under the law. So, will that cause rifts in the family? Possibly. But under the law, does she have a leg to stand on? No. Right?
Question.
Yes.
Just in case, this is relevant or irrelevant.
Yeah, go ahead.
Just in case lawyer A passes away, who's handling all these cases for a client,
Yes.
passes away, then who takes over all those responsibilities?
So it depends. If there's another lawyer in the firm, they can take it over. As I said, the person that prepared the wills and prepared the estate plan doesn't necessarily need to be the person that administers it or helps you apply for it to become the trustee and pay the taxes and figure all that stuff out, right? So you can use an outside lawyer at a different firm. Where it becomes a little bit of an issue, and I've seen this because a lot of the older lawyers are not planning properly, is the practice before was that they keep the original wills.